Afraid I've got the short straw this afternoon. I've got to talk about two absolutely, totally bum decisions. Otto Kahn-Freund was the founder of labour law in this country. Professor Lord Wedderburn followed him, really, and Kahn-Freund wrote that the main object of labour law has always been, and we venture to say will always be, to be a countervailing force to the inequality of bargaining power which is inherent and must be inherent in the employment relationship. I don't think Bill Wedderburn would have agreed with that, and certainly when you look at the case of Edwards and Chesterfield and Botham and the Ministry of Defence, there is no trace of countervailing power to the inequality of bargaining power inherent in the employment relationship. Indeed, Edwards and Chesterfield and Botham and the Ministry of Defence provide a textbook example of the distortion of principle for reasons of policy, and those who want to read more about it should look at Hugh Collins' article in the Industrial Law Journal, which I've cited on the third page. Just remind you of the facts of those cases so far as we need to discuss them this evening. Edwards and Botham were both employees who'd been dismissed for gross misconduct following disciplinary procedures which were expressly incorporated into their contracts of employment. And both cases proceeded on the basis that these breaches of the disciplinary procedure had caused damage to their professional reputations, in particular by reducing their chances of future employment, what the PI lawyers know as a loss of earning capacity. Well, the legal background to Edwards and Botham it starts really with Addison, the gramophone company. And there's always been a myth about Addis, or at least there was a myth until Malik and the Bank of Commerce revealed the truth about Addis. The myth was that damages for loss of earning capacity by damage to reputation resulting from a dismissal in breach of contract was limited to the loss of remuneration for the period of contractual notice. So in other words, the employee couldn't get more than that which they would be entitled to under the notice provision, no matter what the reason for the dismissal was. Malik changed that because in Malik, damages for injured reputation resulting in loss of earning capacity were awarded where the breach of contract by the employer was of the term that was invented effectively, or at least approved by the House of Lords in Malik, the implied term of maintenance and of trust and confidence. Unfortunately, when it came to the final trial, the employees lost on that case. But nevertheless, they established this very important principle. And in Malik, the House of Lords distinguished Addis on two bases. One was that on a proper analysis of Addis, the limitation in it was confined to general damages to reflect the manner of dismissal, but didn't extend to prohibiting a claim for special damages in respect of actual loss caused by the breach of contract. We haven't really got time to go into the facts of Addis, but basically what the House of Lords were saying in Malik is that the restriction in Addis that you can only get your notice money or the equivalent thereof was only in respect of a claim that the manner of dismissal was what you were complaining about. But there were when Lord Steyn analysed Addis, he said, well, it's quite clear from the judgments of the House in Addis that principle didn't extend to a claim for special damages. That's to say, an account of the actual, not special damages, of damages for in respect of the loss caused by the breach of contract itself. That was one basis on which Addis was distinguished. The other was that Lord Nichols said, well, Addis was decided before the invention of the implied term of trust and confidence, and therefore it has no bearing on a claim for damages for breach of that term of the contract. Well, the next case in the chain is Johnson and Unisys, familiar to all of you, I'm sure, where the House restricted the application of Malik to cases where the complaint was about a dismissal. Cases other than dismissal. So the Johnson exclusion zone, as it came to be known, applied to cases where the loss was said to derive from the fact of dismissal, but it didn't apply to prevent claims for damages arising out of any prior breach of contract, such as a breach of the disciplinary procedure, which ultimately led to the dismissal. And the basis for the Johnson exclusion zone was a new principle set out in full by Lord Hoffman, that Parliament, when it introduced the law of unfair dismissal, could not have intended that the law of contract would provide a parallel remedy, one which might exceed the statutorily capped and restricted level of compensation available in tribunals for unfair dismissal. The law of contract, therefore, had to give way. Of course, that proposition wholly ignores the obvious fact that the statutory test for unfair dismissal is not dependent on a finding of breach of the term of maintenance of trust and confidence. Indeed, unfair dismissal doesn't depend on proof of breach of any term of the contract at all. They are, strictly speaking, from a jurisprudential point of view, entirely different and discrete legal concepts. The next case is that of Eastwood and Magnox, and there the House of Lords clarified the zone where an employer's breach of contract prior to dismissal results in loss, then damages could be recoverable. The House followed Johnson in holding that the exclusion zone disallowed claims arising from the dismissal itself. And then we get to Edwards and Botham. Of course, Mark Sutton was the successful advocate in the case of Edwards in the House of Lords. That doesn't prevent me attacking the decision as hard as I possibly can. There, the majority of the Supreme Court upheld the assumed restriction on contractual damages supposedly derived from Addis. They effectively ignored the elucidation of Addis, which the House of Lords had proclaimed in the case of Malik. The rationale was an expansion of the Johnson rationale for the exclusion zone, the assumed parliamentary intention of barring any contractual damages claims for dismissal because Parliament had introduced a law on unfair dismissal. The majority overrode the basis on which Malik had distinguished Addis and extended the exclusion zone, the Johnson exclusion zone. Now it covers not merely a loss arising from dismissal in breach of the implied term of trust and confidence, but it bars a claim for damages arising from dismissal in breach of express terms of the contract as well. And yet it goes further, and the exclusion zone applies not merely to loss flowing from the dismissal, but even from breaches prior to dismissal. So the whole area is completely shut down by the House of Lords in Edwards and Botham. Lords Dyson, Walker and Mance held that a contractually binding disciplinary procedure was not intended to give rise to an action for damages if breached. I mean, that to me, that's just an extraordinary proposition, that when workers enter into a contract of employment which has got an express disciplinary procedure which says what will happen if they're charged with misconduct or whatever other offence it applies to, this is what will happen, this is the process that will be gone through, and only on proper exhaustion of that process will this range of penalties be applied to you. Dyson, Walker and Mance say that is not intended to result in any claim for damages if that procedure is breached. So this is unique in the kinds of contractual terms in a contract of employment. This kind of contractual term cannot result in a claim for damages. Lord Phillips didn't follow that reasoning, but gave an independent reason why such an action for damages was impermissible. He said that it was too remote, that it could have been in the contemplation of the parties that if the employer breached a disciplinary procedure, the employee might claim damages for it. So the upshot is that damages are not available for reputational damage arising from a breach of the contract of employment. But the House made clear that that doesn't bar an action for an injunction. And once again, as a matter of jurisprudence, how can that possibly be? If you can have a remedy by way of injunction for breach of a contract of employment, how can you not have the ordinary remedy of damages for the identical breach? Jurisprudentially, it simply does not make sense. Well, Lords Kerr and Wilson followed the Eastwood rationale, and they would have allowed a claim for loss arising from a breach prior to dismissal, but disallowed one arising from the dismissal itself. But they were in a minority, so their view doesn't count. Lady Hale, in my respectful opinion, gave the only principled decision, and she held that the usual contractual principles of recovery of damages should apply to a contract of employment, and that Parliament could not have be taken to have intended any mitigation of that rule in employment cases by the introduction of unfair dismissal. So how does that leave us? I think it means that the employment lawyer now presented with a potential claimant who complains of a breach of a contractual term which has damaged their reputation and injured them on the labour market, it can only realistically look for an injunction claim. There is some scope for thinking that there might be a legal challenge to Edwards and Botham, and indeed an attack on the Johnson exclusion zone itself, but it's going to have to be a well-funded litigant that attempts to rewrite the law of damages in relation to contracts of employment. Well, now let's come to the second case that I need to talk about, which is one of many heroic defeats that I undertaken, and that's the case of Mattu. This was a case in which the remedy of injunction was sought to restrain damage to career prospects, which was preserved by Edwards and Botham. The facts were that Dr. Mattu was a cardiologist who'd been suspended for a long period of time, and that matter had been dealt with, and he was undergoing a process of reskilling to get him back to work as a consultant cardiologist. And there was a dispute between him and his employing trust about the terms of the reskilling. He wanted it to include research, and they said no, that's not necessary. So he refused to sign the reskilling agreement, and charge was disciplinary charge was brought against him for refusing to carry out a reasonable instruction, and it was said that he was unmanageable. There were some subsidiary charges as well, which we needn't trouble with this evening. The disciplinary charges were heard. The trust then dismissed him for gross misconduct, having found him guilty. Mattu didn't accept the dismissal, claimed that it was repudiatory, and sought an injunction to prevent the dismissal taking effect. And he lost in the High Court, and we subsequently lost in the Court of Appeal, and it's the Court of Appeal decision that we need briefly to look at this evening. But before we do that, one point is very important for the proposition that we've derived, or the only point that remains arguable for employment lawyers after Edwards and Botham, and that is that in the Mattu case there was never any dispute that Mattu would be entitled to an injunction if he could establish a breach of the contract of employment. There's an argument about whether, as a matter of discretion, an injunction would be given to him and the facts of that particular case. But the issue of principle as to whether an injunction could follow, not merely to restrain a breach of contract, but to restrain dismissal itself after the dismissal had been announced and a letter of dismissal written, was not a point which was challenged by the employer. And the reason for that I've set out in, I think it's paragraph 22, reference to a whole series of cases, one of which was one of Mark's and mine. The principal issue in Mattu's case was a different one. He relied on Article 6 of the European Convention to say that he'd been denied the opportunity of a fair trial, which Article 6 guarantees, and in particular an independent and impartial disciplinary panel, which Article 6 makes explicit. The reason that this thought occurred at all was because from 1951 until 2005, senior medical staff in the NHS were protected by a procedure dealing with serious allegations of serious misconduct or incompetence, which gave them the right to an independent and impartial tribunal. Those who do medical cases will know the last reincarnation of that was HC 9099. The statutory instrument, or the document which came into effect by reason of a statutory instrument that got rid of that, was maintaining high professional standards in the modern NHS, which effectively said that doctors, instead of having an independent and impartial tribunal to deal with such allegations, were subject to the ordinary disciplinary code of the employing NHS trust. Well, Mattu was saying, well, be that as it may, I'm entitled to Article 6, and the basis of his claim was twofold. The first and most important was that Article 6 is engaged where there is a determination of the right to practice one's profession. Now, plainly, the obvious case in which that will arise is when a statutory regulatory body seeks to deprive a solicitor or barrister or a doctor or some other professional of their registration and thereby their right to practice their profession. But the House of Lords, in a case called Wright and the Secretary of State for Health, according to Lady Hale, applied that principle even in private disciplinary proceedings. And it appears to me that on the face of it there is no material difference between the determination of the right to practice one's profession made by a public body exercising statutory power to regulate the whole profession and such a determination by a public body exercising contractual powers regulated by statute. And there's some authority to support that. But the Court of Appeal was clearly mindful of the floodgates argument that if Article 6 applied to Mattu, it might have far wider repercussions, not merely confined to the public sector and professionals, but possibly extending to the private sector and non-professionals as well. I think the logic of that is dubious, but Floodgate's argument is quite clearly uppermost in their mind. Lord Justice Stanley Burnton solved the problem by holding that the right to practice one's profession couldn't be engaged since it was too uncertain and too great a burden on a trust to establish prospectively whether the doctor might lose his profession in consequence of an adverse finding in the disciplinary hearing or not. And of course, that one can see that there may be cases where it's difficult to establish whether an adverse finding on a charge of misconduct might ruin a doctor's career. Lord Justice Stanley Burnton disagreed with the holding of Lady Justice Smith in the case of Kulkarni, where a trainee doctor charged with sexual misconduct against a patient would be likely to lose his career and so was entitled to the benefit of Article 6. In that case, he was claiming legal representation. That was an obiter holding. But in Matu's case, when one thinks about it, one might have thought that there couldn't be much doubt, prospectively or retrospectively, about the likely effect on the consultant's career of a charge of gross misconduct resulting in summary dismissal for refusal to obey a lawful and reasonable instruction, rendering the doctor unmanageable. But the Court of Appeal had a whole armoury of other points to sink my Article 6 argument. Lord Justice Elias and Sir Stephen Sedley took a more fundamental point, a point which I have to say I don't really understand, but maybe that wiser heads here can explain it to me. They said that the decision to uphold the charges and to dismiss the doctor was not a determination of his civil rights at all. It was instead the exercise of the employer's right under the contract to discipline the doctor. To which my simple mind says, well, so what? I'm sure that's true. They were exercising their right, but what they were doing in the exercise of their right doesn't make it illogical that the effect of it was to determine the doctor's right. Anyway, that's part of the ratio of the case. But the Court of Appeal went further. They said that Dr. Mattu wasn't deprived of his right to a career at all. Since his GMC registration still stood, he therefore still had the right to practice his profession. The fact that no NHS employer would touch him with a barge pole was neither here nor there. They were free to do that, and the employing trust didn't guarantee that other employers would employ him. It seems to me that's a flawed argument, because the European Court of Human Rights has made clear in many, many cases, in many, many fields, that guarantees of fundamental rights have to be effective. And it's no good saying you've got a theoretical right to practice medicine which you can't actually put into effect. But there was more. A further reason, supported by Lord Justice Stanley Burnton and more tentatively Lord Justice Elias, was that even if Article 6 was engaged, there was access to an independent and impartial tribunal which cured the defect of the disciplinary procedure, which everybody accepted was not conducted by an independent tribunal. It was the chief executive officer. And this proposition is that you can bring a breach of contract claim in the county court alleging not merely a breach of procedure, but also challenging the substantive grounds for the decision. So what they envisage is that the employee can go to the county court and say, I wasn't guilty of theft as charged, and the contract required the decision to be true, and therefore I now wish to rehearse all the evidence about whether the charge of misconduct was properly founded. I must say I find that a fantastic extension of the law. It's not the law as I had previously understood it to be, but it does mean that employment lawyers need to be familiar with this case just to see whether in fact you have got the facts to support a challenge to the county court on the basis of the substance of the a challenge to the substance of the reason for the dismissal. I mean, it's a curiosity too, because of course employment tribunals are expressly prohibited from inquiring into the justification for the dismissal, whether the charge is approved or not. That's one of the things they're not allowed to look at. They can only look to see whether the decision was within the within the band of reasonable responses of reasonable employers. I'm coming to the end, Mark. But the Court of Appeal gave so many grounds for chucking me out that I wouldn't do justice to them without mentioning the others. Lord Justice Elias held that if Article 6 was engaged, it was a matter for the state to impose an Article 6 compliant procedure rather than a matter for the public sector. Dr. Mattu prayed in aid Article 6 as protecting a right to a good professional reputation, and there is authority to support that proposition as deriving from Article 6 and indeed Article 8 of the Convention. Only Lord Justice Elias troubled to deal with that and said that the employer was not determining the right to good professional reputation but merely exercising its contractual right. So there we are. Two bum decisions, as I see it, and particularly harsh, it seems to me, on employees, given the present government's changes to unfair dismissal legislation, the extension of eligibility from 1 year to 2 years, which excludes 2.7 million workers, and the changes now to introduce fees, which I think are likely to shut out at least 50% of claims. And now we see they're proposing to cap compensation for unfair dismissal, which will reduce the median award, which currently stands on the latest statistics at £4,560 as the median award for unfair dismissal, and that will reduce, no doubt, yet further. Thanks for listening.